So good day, everybody, and greetings from the UN in Geneva. Happy to present today this study that I've been doing with a lot of help along the past years. So the study finds that there may be a way for countries to regulate cannabis, non-medical cannabis, and potentially the non-medical use of other drugs as well, but I have been focusing on cannabis in this particular study. Cannabis has a special legal regime in the single convention, and that deserves a specific attention. I believe most drugs would deserve this specific inquiry, specific attention given to their particular treaty history and the specific legal framework that might apply to their non-medical use. And in particular, it relates to the possibility, the ability, the existence of ways to actually reduce the harms from the substances that we want to regulate for non-medical use. So I'm going to try to present this briefly. I invite you to read the study. It's quite long and dense, and it's international law, so it's always a bit complex, but I have tried to make the study as comprehensive as possible. It's a textual interpretation, so it's based fully on the interpretation of the binding provisions within the single convention and other treaties. But then it goes to look for support, to look for confirmation or information in subsidiary means of interpretation, as can be other treaties related, concluded by some or part of the parties, as could be the commentary, for instance, and obviously the work that led to the convention, such as the work of the plenipotentiaries and all the drafting history of the treaty provisions at stake. So Article 4 on general obligations, as the board mentioned in the 2018 brief on the Bill C-45 of Canada, legalizing non-medical cannabis. And I do agree, indeed, the way Bill C-45 has been crafted to legalize cannabis for non-medical and non-scientific purposes, this way cannot be reconciled with the obligations of Canada under Article 4, paragraph C of the Single Convention. And indeed, as INCB mentioned in that same brief, Article 4, paragraph C has this wording. However, I suggest that we have not always given the proper attention to the entirety of the general obligation contained in Article 4, because as we can see here, the INCB put emphasis on the fact that states have to limit exclusively to medical and scientific purposes a series of activities related to drugs, but this is subject to the provisions of the single convention. So the limitation, the exclusive limitation, is subject to the provision of the convention. This provision, we can find it in the text, but sometimes the commentary is just making things easier. Indeed, these provisions to which paragraph C is subject are three provisions which all apply to other than medical and scientific uses. It's Article 49 and Article 2, paragraph 9 for what concerns cannabis. And then we have Article 27 for the coca leaf, but we're not considering it today. And these all concern other than medical and scientific uses, including for coca leaf, which is actually a flavoring agent, which is a non-medical use flavor in beverage. So the limitation, what we have to understand is that the general obligation is not to limit exclusively, but to limit exclusively subject to some exemptions. And this is why in the preamble, we don't find this exclusive limitation, but just a limitation. The goal is to limit, not exclusively, and limit in a way that is generally acceptable. And that's, I think, absolutely fundamental to see this distinction between the exclusive limitation balanced by the exemption and the generally acceptable limitations that it echoes in the preamble. So in addition to this, we don't find any textual clear obligation to prohibit in the convention. We just have recommendation or option to prohibit substances in Schedule 4 if certain conditions are given, but we will find an obligation to prohibit. So that's also an element to consider. It's just simply not there in the treaty, and if it's not there, it cannot bind us. And the objective purpose, finally, of the treaty, as the INCB recognizes itself, is the protection of the health and welfare of humankind. And to reach that goal, the treaty and the parties proposes themselves to establish this series of control measures in order to reach that goal of protecting the health and welfare. So the provision, the interpretation of the treaty has to be guided by this goal, and it has always been. And even countries that say we will, for instance, for substances in Schedule 4, we will apply prohibition. They do so because they believe in good faith that applying prohibition will contribute to improving and protecting the health and welfare of humankind. That's, I think, something we can agree on, even with those, even if we don't agree with the fact that it will work, but we can agree that it's in good faith their view of reaching the goals of the treaty of protecting this health and welfare. So abuse is abuse, ill effects, addiction, misuse. We have a series of words that are analyzed in the report I am presenting, the high compliance, page 66 to 73. The word abuse is present, so we have to note changes between the original single convention and the amended single convention. Initially, we had the word addiction present a lot. In high compliance, there is also an annex that that lists every single mention of the word abuse and related terms and explain their context. And what we find is that not only by the fact that abuse is here to replace addiction with the 1972 amendment, but also with the context in which it is presented, abuse is a medical condition. It's a disease. It's certainly not equivalent to all uses or to all non-medical uses. Abuse is in the way that it is defined, but also in the way that it was defined at the time by the medical literature and the doctors. It has evolved, and nowadays in the international nomenclature of diseases, where we used to find abuse, we now find substance use disorders. And in the 61 Convention, when we try to understand what abuse could mean just by reading the text, we see that it's always related to ill effects, to conditions, to the question of treatment and prevention. What do we treat and prevent? Diseases, right? So in order to prevent the health and welfare of humankind, parties have to avoid abuse, to avoid the substance use disorder and all other related harms, and that kind of makes sense. And so quickly, because I'm short on time, but this is a way I try to represent graphically what the convention establishes. So this closed loop, this limitation that we can see here in red. So the licit uses for medical, the licit medical uses are these one in blue. The licit non-medical uses are the ones that are exempt under one of the three articles that Article 4C is subject to, 29, 27, or 49. And finally, what is neither medical and scientific nor non-medical as exempt under the relevant provision, that is the remaining uses that are illegal, illicit. But not all non-medical uses are illicit. This coheres obviously with the object and purpose. So Article 2, Paragraph 9 is the current article that I identified in the, and I'm not alone, obviously, others have identified this article as the one that provides a legal framework for non-medical cannabis in our current context in 2022. Countries can, as you see here, are not required to apply the provision of this convention to drugs commonly used in industry for other than medical and scientific purposes, as long as they ensure either by denaturing or other means that the drugs cannot be liable to substance use disorder, to abuse. We also have this provision, this mention of the harmful substances cannot be in practice recovered, and some people have said that this somehow forces into denaturing the substance, because denaturing and making the harmful substance not be recovered is somehow the same thing, or we can at least understand it as the same thing, but it's not possible to have the same thing, because if parties are given the choice of denaturing or something else, they cannot then be forced into denaturing in another provision. That opposes the principle of effet utile, the principle utret magis valeat quam pereat, which says that we cannot interpret a treaty provision in a way that it would render parts of its word, parts of its provision useless or void of any legal effect. So if we consider that the substance has to not in practice be recovered, meaning we have to remove the active compound or put other ingredients that would avoid the active compound to be used in the end. It's denaturing, and then the words "or by other means" are void of any effect, and that's not possible. We have to; these words have been inserted here on purpose, and they must have effect. So countries must be able to not apply the provision of the convention by applying other means than denaturing to these drugs. And this is to reduce abusive effects and harmful substances. So the only thing that makes sense and that does not render any part of the section void is by considering that harmful substances is the harmful substance of the drug, the fact that it is harmful, the harmfulness of it. In addition, if we try to interpret, and again, that's for the principle of effet utile, if we try to interpret that THC is the harmful substance in cannabis that should not be recovered. First, it's not that evident to think that it's easy to recover pure THC from cannabis. It's not easy. That's why we have some problems sometimes when people try to do it at home and they have accidents, because it is not easy. But anyway, even if we try to consider that it's easy, if THC is a harmful substance that has to be, so the active ingredient of cannabis must be removed for the substance to be exempt, the provision has to work for all drugs. So what would it be for morphine when it's a single compound drug? Would we have to remove morphine from morphine in order for it to be exempt? That makes no sense. So if it cannot make sense for morphine, it cannot make sense for cannabis. That's again the principle of effectiveness. We would render the Article 2.9 void in the case of morphine and not in the case of cannabis. In addition, we know that morphine has been given as an example of these drugs that can be exempted for processes of photography, which personally I would refer to as a recreational purpose, but that's just let's say a private joke. But the morphine exempted for photography was not denaturated, was not denatured. It was morphine, because if it was not, it would not have been useful in these processes of photography. So again, Article 2.9 allows to, according to the true general rule of interpretation, that is effet utile, vis ut ret magis valeam quamperat, allows to consider that either denaturing or other means are possible to exempt drugs, as long as the goal of reducing abuse, and this in order to contribute to the ultimate object of protecting the health and welfare, as long as this is met. Again, on Article 2, paragraph 9, it's important to consider the intertemporal aspect of this article. As the drafters explained, but it's also, we can see it in the treaty, but it's very clear in the official records and also in the commentary. Article 2.9 was thought for the future, was made as something that a future condition which might never arise, which might or might not arise. And that's elements of intertemporality which allow other elements of intertemporality are the fact that the drafters clearly balanced, either we will include a flexible amendment procedure, or if we don't, then we will include Article 2, paragraph 9. It was one or the other, and the drafters decided not to include the amendment procedure, the flexible amendment procedure, and therefore they decided to include Article 2, paragraph 9. So these two provisions had the same weight in terms of both them being thought for the future. An amendment is also something that we don't adopt a treaty to amend it the next year. We adopt it, the amendment is there for the future when there are developments that we cannot anticipate. And it's the same thing for Article 2, paragraph 9, and that's called intertemporality. And in addition, by doing that, if they were not sure of including it and preferred or at some point preferred the amendment until they preferred Article 2, paragraph 9, it's also because the language was vague. The harmful substances, the commonly used in industry, all of this is not defined in the treaty. It's very vague, and it could be interpreted in fairly different manners, including in a manner that allows the legalization of cannabis. And even though the drafter might not have been just aware of just that as such, they were clearly aware that the drafting could have been improved, and that's France saying it at the almost the last meeting during the negotiation. But at the beginning of the negotiation, the USSR also mentioned that the language could be improved and that other than medical and scientific use was very broad, and industry as well. They knew that, but they still decided to include it. And the intertemporality allows us to look at the Article 2, paragraph 9, with the terms of today instead of the terms of 1961. That's quite interesting because obviously the cannabis industry, that is a term well used today, echoes the common use in industry. And obviously we also mention a lot the non-medical use of cannabis as the standard term to refer to recreational use, so that echoes the non-medical use in the convention. But also the intertemporality allows to reconcile the provision of exemption for medical use under Article 2, paragraph 9 with the provision of exemption for medical use under Article 49. It looks like they are exempting the same thing, that they are the same, and therefore they conflict, but this is erroneous. They do not conflict because they have different temporal applications. Article 49 was thought for the part, not only they have different temporal application, but they also refer to different subtypes of other than medical and scientific uses. Not only so the medical uses that were, the non-medical uses that were exempt under Article 49 were those uses that were traditional in the territories and that were permitted as of 1st January 1961. That's not the case of the uses under Article 2, paragraph 9. These are only common in industry. So that's a difference in terms of subtypes of uses. And Article 49 was made to expire after a certain period. So now there is some debate as to whether the period of expiration is that of the 61 Convention or of the 61 Convention as amended in 1962. The date would change, but anyway, in both cases, it's passed already. So Article 49 has expired. It is not applicable anymore. But then we have this intertemporal Article 2, paragraph 9, which was thought to maybe apply in the future that we don't know of. And that's precisely why it is complementary with Article 49 once it has stopped to apply, once we have discontinued these uses that were traditional before 1st January 1961, then we can authorize new uses, the ones that are common in industry. So obviously we can discuss the content of willing to prohibit or to discontinue traditional uses and allow only those that would be industrial. That's obviously questionable, but still it's still allowing uses for non-medical uses legally after Article 49 expired. And so as of today, or as of at least if we consider that cannabis is common in industry, and that recreational use is non-medical use. Therefore, if the country that considers that exempt or at least frames its legislation in a way that it complies with both subparagraph A, reducing substance use disorder and other harms, and subparagraph B, submitting statistical information to the INCB, if the country complies with both, then the uses that are so exempted would be licit under the convention, and obviously they will be undertaken under legal authority. So in Article 33, for instance, where we see the possession of drug is not permitted except under legal authority, and Article 2, paragraph 9 provides that legal authority. If we jump to the 1988 Convention Against Trafficking, it's the same thing. The 1988 Convention never calls against cannabis generally. They call against these activities that are already illicit under the 61 Convention or contrary to the 61 Convention. We can see this, for instance, but it's all along the 88 Convention. In Article 3, we see it again in Article 14. It's another example here. The 88 Convention calls to eradicate illicit cultivation of cannabis and other narcotic plants, not the mere cultivation. And it is better that way, because calling to eradicate any cultivation of cannabis would clearly go against the 1961 Convention, which provides for its cultivation for not only medical and scientific purposes, but also industrial and horticultural purposes. The 1971 convention as well, I have to mention it, but it's clear. I invite people interested to go look at footnote 105, 105 in the high compliance report. The footnotes in this report are, as I said at the beginning, crafted to serve as a toolkit and to provide supporting information. So this footnote explains why the 1971 convention is not relevant, except if we talk about pure THC. And it's true that in high compliance, I'm not talking about pure THC. I'm talking about the cannabis that people use for recreational purposes, which is rarely pure THC. It's rather right cannabis or cannabis resin. So I don't really address it, but the 1971 convention would apply only in the case of that THC being pure isolated compound. As long as the THC is part of the cannabis plant, the cannabis resin, or part of the extract and tincture of cannabis, the 1971 convention has no effect, does not apply. And that's something that is obviously recognized by the INCB itself, in particular in its 2014 contribution to the high-level review of the member states' commitment to the political declaration plan of action, and a number of other sources. And then, so to get back to the beginning, Canada has legalized cannabis and said, I am in non-compliance with the 1961 convention. It is true. But if they were to embed in their legislation harm reduction, strong measures aimed at effectively preventing the harms and likelihood of abuse from cannabis in their legislation and obviously in policy, and be able to, in good faith, prove that they are doing so. And if they were reporting, according to Article 2, Paragraph 9, subparagraph B, reporting to the INCB, they would likely be in compliance with Article 2, Paragraph 9, and by doing so, they might be in compliance with Article 4, subparagraph C. But obviously, if foreseen differently, as foreseen currently, they are not. And that's what is interesting. How should countries consider these international dispositions when they are crafting their law nationally, and what kind of good faith commitment should they share with the international community in order to convince that they are still willing to contribute to these goals of protecting the health and welfare of humankind, albeit maybe differently than other countries by regulating particular use, but still they are contributing to this goal. And in addition, and just to finish, sorry if I was a bit long, but the bill of Canada, the law could also have been foreseen differently in order to fit with the overreaching goal of the international community beyond the pure international law and drug control. There are also other obligations that relate to the question of, for instance, biodiversity, of human rights, also environmental concerns, and obviously the non-inclusion in many legally regulated cannabis markets, the lack of inclusion of the people that have been involved in illicit market, the fact that they are not included in the licit system prevents, to my opinion, and to the opinion of a number of persons interested in the topic, prevents a smooth and a comprehensive move towards a licit regulating system, and continues to maintain part of the illicit markets subsisting. So comprehensive social approaches that consider the inclusion, the incorporation of these stakeholders in the licit market is absolutely essential, and obviously it's not covered by the 61 convention, but that are elements that I thought should be considered in the discussion today, questions of environment, social justice, biodiversity, and generally sustainable development. I thank you for your attention, and I hope that I've not been too long.